So the first problem here was that the quality assurance director wasn't seeing the customer complaints.
We had a question on the verdict form, is that correct?
Yes, Your Honor, Joel Odou for Real Water. We've clarified it, but I just wanted to make sure that the record is clear, because obviously I was not yesterday, so I apologize if I misspoke yesterday. We understand the court's ruling. The court has made a ruling on the verdict form and inserted some language for the damages of the parents. For the clarity of the record, what we were asking was to delete the parents and include them for past pain and suffering in one category, and for future pain and suffering in the other, and have that include their future mental anguish for themselves and for their children. We understand the court has overruled that and made a different ruling, and that the proposed verdict form conforms to the court's ruling yesterday, even though my argument was a little confused yesterday, so I apologize for that.
Oh, that's okay, thank you. Anything from Plaintiffs?
No, Your Honor.
Thank you, and yeah, I did, when it was raised in chambers, I double checked it. As the verdict form currently stands is in accordance with my ruling yesterday. And then in terms of the jury instructions 1 through 26, have plaintiffs had an opportunity to review those?
Yes, Your Honor.
Any issues?
No, Your Honor, those are consistent with what we discussed and agreed upon with Real Water.
Thank you. And the defendants had an opportunity to review the jury instructions 1 through 26.
Yes, Your Honor, I'm just triple checking. And they do match our discussions and agreements.
Thank you. With that, scheduling wise today, thoughts on the timing things?
Judge, I think mine's gonna run just in 2 hours. So after break for, I thought I'd just leave it up to the jury, ask them, if they want to break for lunch, they can just raise their hand over the court. They want to blow through, lunch after I'm done.
I'm going to need a break before.
Judge, why don't I look at a good break spot, break after an hour?
Anything from the defense?
That is agreeable, Your Honor.
Okay, yeah, let's do that. There really aren't that many instructions, but bear with me a second. We get organized up here myself. Back, ladies and gentlemen, thank you as always for your service and patience. Both are very much appreciated by all of us. So with both parties having rested, I'm about to instruct you all on the law as it applies to this case. So I'll be reading the jury instructions. You will have a copy of these instructions when you go back to deliberate. You'll also have a copy of the verdict form with you when you go back to deliberate. After my instructions, we'll begin closing arguments. We'll break some point in between for lunch. You'll be provided lunch in the jury room. And then we'll resume further with closing arguments. Need to get my fingers sticky stuff so I can turn this page. Jury instructions. Instruction number 1. Members of the jury, it is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. Number 2, in these instructions and on the verdict form, defendants, AffinityLifestyles.com Inc., a Nevada corporation, DBA Real Water, and Real Water Inc., a Delaware corporation, are collectively referred to as Real Water. 3, if in these instructions any rule, direction, or idea is repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which instructions are given has no significance as to their relative importance. Number 4, one or more of the parties in this case is a corporation. The corporation is entitled to the same fair and unprejudiced treatment as an individual would be under like circumstances, and you should decide the case with the same impartiality you would use in deciding a case between individuals. 5, the masculine form is used in these instructions if applicable, as shown by the text of the instruction, and the evidence also applies to a female person or a corporation. Number 6, although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. 7, if during this trial I have said or done anything which has suggested to you that I am inclined to favor the claims or position of any party, you will not be influenced by any such suggestion. I have not expressed, nor intended to express, nor have I intended to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inference should be drawn from the evidence. If any expression of mine has seemed to indicate an opinion relating to any of these matters, I instruct you to disregard it. 8, you must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not make any independent investigation of the facts or the law or consider or discuss facts as to which there is no evidence. This means, for example, that you must not on your own visit the scene, conduct experiments, or consult reference works for additional information. 9, the credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which he or she testified, the reasonableness of his or her statements, and the strength and weakness of his or her recollection. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of this testimony which is not proved by other evidence. 10, in determining whether any proposition has been proved, you should consider all the evidence bearing on the question without regard as to which party produced it. 11, the evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are 2 types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as testimony by a witness about what the witness personally saw or heard or did. Circumstantial evidence is the proof of one or more facts from which you could find another fact. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorneys stipulate, meaning to agree, to the existence of a fact, you must accept the stipulation of evidence and regard that fact as proved. Questions are not evidence. Only the answer is evidence. You should consider a question only if it helps you to understand the witness's answer. Do not assume that something is true just because a question suggests that it is. You must also disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. 12. During the trial, you received deposition testimony that was read from the deposition transcript and or shown by video. A deposition is the testimony of a person taken before trial. At a deposition, the person took the same oath to tell the truth that would be taken in court and is questioned by the attorneys. You must consider the deposition testimony that was presented to you in the same way as you would consider testimony given in the court. 13. When a party to a lawsuit is a corporation, the other party may schedule a deposition under Nevada Rule of Civil Procedure 30B6, requiring the corporation to designate one or more officers, directors, managing agents, or representatives to testify on its behalf on matters known or reasonably available to the corporation. The person so designated shall testify as to matters known or reasonably available to the organization. The testimony of the Rule 30B6 designee is binding on the corporation. 14. An attorney has a right to interview a witness for the purpose of learning what testimony the witness will give. The fact that the witnesses talked to an attorney and told that attorney what he would testify to does not reflect adversely on the truth of the testimony of the witness. 15. Witnesses who have special knowledge, skill, experience, training, or education in a particular subject have testified to certain opinions. This type of witness is referred to as an expert witness. In determining what weight to give any opinions expressed by an expert witness, you should consider the qualifications and believability of the witness, the facts or materials upon which each opinion is based, and the reason for each opinion. An opinion is only as good as the facts and reasons on which it is based. If you find that any such fact has not been proved or has been disproved, you must consider that in determining the value of the opinion. Likewise, you must consider the strengths and weaknesses of the reason on which it is based. You must resolve any conflict in the testimony of the witnesses, weighing each of the opinions expressed against the others, taking into consideration the reasons given for the opinion, the facts relied upon by the witness, their relative credibility, and their special knowledge, skill, experience, training, and education. 16. Expert witnesses testified about their reliance upon books, treatises, articles, and or statements that have not been admitted into evidence. Reference by the expert witness to this material is allowed so that the expert witness may tell you what they relied upon to form their opinions. You may not consider the material as evidence in this case. Rather, you may only consider the material to determine what weight, if any, you will give to the expert's opinions. 17. Plaintiffs assert claims for strict liability for a defective product. Real Water has admitted that the Real Water product that it manufactured was defective and unreasonably dangerous. Real Water has also admitted that its defective product caused the injuries asserted by each plaintiff. Thus, the only issues remaining to be determined by you are: 1. The amount of compensation that should be awarded for each plaintiff's general damages. 2. whether each minor plaintiff needs future neuropsychological monitoring and treatment. And 3, whether Real Water is liable for punitive damages. 18, you must determine damages for each plaintiff. In determining the amount of damages suffered by each plaintiff, you will take into consideration the nature, extent, and duration of the injuries you believe from the evidence that each plaintiff has sustained, and you will decide upon a sum of money sufficient to reasonably and fairly compensate each plaintiff for the following items: the physical and mental pain, suffering, anguish, disability, permanent injury, and loss of enjoyment of life endured by each plaintiff from the date of his or her incident to the present; the physical and mental pain, suffering, anguish, disability, and loss of enjoyment of life, which you believe that each plaintiff will be reasonably certain to experience in the future as a result of his or her injuries; the mental anguish suffered by the parent plaintiffs related to the injuries suffered by their children from the date of the child's incident to the present; the mental anguish which you believe that the parent plaintiffs will be reasonably certain to experience in the future as a result of the injuries suffered by their children. The court has already determined the amounts of past and future medical expenses for each plaintiff as a result of his or her injuries. Therefore, you should not include past or future medical expenses in your damage awards to each plaintiff. 19. No fixed standard exists for deciding the amount of pain and suffering damages, nor is the opinion of any witness required as to the amount of such reasonable compensation. You must use your judgment to decide upon a reasonable amount based on the evidence and your common sense. 20. The plaintiffs have the burden of proving their damages by a preponderance of the evidence. A quote, preponderance of the evidence, close quote, means such evidence as, when considered and weighed against that opposed to it, has more convincing force and produces in your mind a belief that what is sought to be proved is more probably true than not true. In determining whether a party has met this burden, you will consider all the evidence, whether introduced by the plaintiff or the defendant. 21. Whether any of these elements of damages have been proved by the evidence is for you to determine. Neither sympathy nor speculation is a proper basis for determining damages. However, absolute certainty as to the damages is not required. It is only required that each plaintiff prove each item of damage by a preponderance of the evidence. 22. You may consider whether you should award punitive or exemplary damages against Real Water. Punitive or exemplary damages are to make an example of or punish wrongful conduct. You have discretion to award such damages only if you find by clear and convincing evidence that the defendants were guilty of oppression, fraud, or malice in the conduct providing the basis for liability. Malice means conduct which is intended to injure a person, or despicable conduct which is engaged in with a conscious disregard of the rights or safety of others. Oppression means despicable conduct that subjects a person to cruel and unjust hardship with conscious disregard of the rights of that person. Fraud means an intentional misrepresentation, deception, or concealment of a material fact known to a defendant with the intent to injure or deprive a person of rights or property. Conscious disregard means knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to avoid those consequences. At this time, you are to decide only whether Real Water engaged in wrongful conduct warranting an award of punitive damages, and, if so, whether the award of punitive damages against Real Water is justified by the punishment and deterrent purposes of punitive damages under the circumstances of this case. If you decide an award of punitive damages is justified, You will later decide the amount of punitive damages to be awarded after you've heard additional evidence and instruction. 23. Clear and convincing evidence is that measure or degree of proof which will produce in your mind a firm belief or conviction as to the allegation sought to be established. It is an intermediate degree of proof, being more than a mere preponderance, but not to the extent of such certainty as is required to prove an issue beyond a reasonable doubt. Proof by clear and convincing evidence is proof which persuades you that the truth of the contention is highly likely. 24. When you retire to consider your verdict, you must select one of your number to act as foreperson who will preside over your deliberation and will be your spokesperson here in court. During your deliberation, you will have all of the exhibits that were admitted into evidence, these written instructions, and a special verdict form which has been prepared for your convenience. In civil actions, 3/4 of the total number of jurors may find and return a verdict. This is a civil action. As soon as 6 or more of you have agreed upon each answer required by the directions in the special verdict form, you must have the verdict signed and dated by your foreperson and then return with it to this room. 25. If during your deliberations you should desire to be further informed on any point of law or hear again any portions of testimony, you must reduce your request to writing signed by the foreperson. The officer will then return you to court where the information sought will be given to you in the presence of the parties or their attorneys. Remember, the court is not at liberty to supplement the evidence. 26. Now you will listen to the arguments of counsel and will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberation by the evidence as you understand it, and remember it to be, by the law as given you in these instructions, and return a verdict which, according to your reason and candid judgment, is just and proper. That concludes the jury instructions, ladies and gentlemen. Are plaintiffs ready to argue?
Yes, Your Honor. May I proceed, Your Honor? Good morning, ladies and gentlemen. Let me start by thanking you on behalf of all plaintiffs, just like Judge Hardy thanked you many times. We appreciate you performing jury service. We know jury service is difficult, but the jury is what our entire justice system is based on. Without you, there's no justice. And so again, thank you. Let me get started. There are two general things in this case for you to decipher. One, the amount of compensatory damages for each one of the plaintiffs. And two, whether or not punitive damages should be awarded. So let's start with the verdict form. This is the form that you will get back in the jury room. Okay, this is the first page. This has the name of all the plaintiffs on it. Next, Shane.
You want to go through the whole form?
Yeah, let's go through the whole form. Okay, this is the first question. So see where it says fill in the amount of past physical and mental pain, suffering, anguish, disability, permanent injury, loss, and drug of life. And then the second question is future physical and mental pain, suffering, anguish. So there's a distinction here between the past, what has happened since the date of the injury to now, that's the past, and the future. Okay, so what you're trying to do is you're trying to evaluate what is the appropriate amount for these families for what's happened in the past and what's happening in the future. Okay, so go back up, Shane, to number one. So for each one of the plaintiffs, again, that's the baby, Noah. Remember I told you Brian B is the father first and baby's Noah. So each one of the 5 babies here, you fill in the amount for the past, all right? And then is for the physical and mental pain and suffering, the anguish, the disability, the permanent injury, the loss of enjoyment of life. And I'm going to be talking a little bit about the permanent injury because we have a lot of evidence on that. And then, like I already said, that's the first 3.5 years since the date of most of the injuries. November 15th, I think, is the first date we were in the hospital. So it's roughly 3.5 years. And in the future, pain and mental anguish, you know, how long is each one of these children going to live? 60 or 70 years? That's designed to compensate for that entire time. Okay? So when you're back there thinking about it, then the next is just a yes or no. Okay? Do they need future neuropsychop? I'm going to let Mr. Merkovich handle that one. Okay? Do they need that? He's going to explain that to you. It's just a yes or no. Next, please. We have adult plaintiffs in this case. As you've heard, we have Chris Wren Sr., Chris Brian Wren, Emily, and we have Mr. Tagano. Okay, so I'm going to talk to you a little bit about Chris's injuries again, Chris Brian Wren, and Emily, and Mr. Parker's going to talk about Mr. Tagano. So the same thing here, okay? Past and future. All right, so the past, again, is 3.5 years. The future would be less for these people because they're adults. They're not going to live as long as the children, so you have to take that amount. I'm not going to say 50, 60 years for them. You know how old they are. You can do that. But that is the same kind of calculation. Next one, Jim. These are the damages for the past mental anguish relating to the child's injury. So the parents testified, this is what's been going on for the last 3.5 years. The anguish in the hospital, the anguish up to the present. That's what that's intended to get to. Next one, please, Jim. This is the future. Same thing, future. Again, Mr. Merkovich is going to talk to you about that. Next, please. And then the punitive damages question. Are they liable for punitive damages? So it's just a yes or no. All right. So let's start with hydrogen. And I told you at the very beginning that you'd hear the word quite a few times during the case. You heard the word quite a few times during the case. So the injuries in this case were all caused by drinking water with hydrogen in it, bottled water laced with rocket fuel. Here's a slide of the molecule. Remember Dr. Madgen told you about it? Next one, Shane. No dispute, you heard all the witnesses testify that this was rocket fuel. Again, it's the same fuel that was used to launch the rockets to the moon. Same fuel that, next one, Shane, Elon Musk uses every day. No dispute, next one, Shane. No dispute, these are the children. These are pictures of the 5 children, Severin, Chris, Hera, Lyric, London, 2 twins. We've got Christopher Wren, Emily, and Tagano. So these are all the 8 plaintiffs that had acute liver failure. Some of the parents are in here just for the past and future mental anguish, but these all had acute liver failure. Next, Shane. So, beginning of the case, remember I played you the 20-second video. That was a little clip from the 2-minute long video that I think you've seen twice during the case of Lyric in the hospital when she had a coma because of the encephalopathy. So the question we posed at the very beginning was, what happened to this baby? Well, we know now what happened to this baby. The Southern Valley Health District, CDC, found that the baby had acute liver failure, the baby drank real water, the FDA found the hydrazine in the real water. Eurofins tested retail bottles, 7 out of 7 retail bottles had objective evidence. Hydrazine causes acute liver failure. The hydrazine in the real water caused the acute liver failure. No dispute about this, okay? And so I'm just showing it to you one more time. And hydrazine is toxic. We know it's toxic. Every doctor that took the stand told you that hydrazine was toxic. Every witness that was involved with bottled water injury, whether it was for the plaintiff or the defendant, told you shouldn't have a drop of hydrazine in bottled water. And so remember at the very start of the case when we did the opening statements on Friday, seems like a lifetime ago, but it was actually a week ago Friday. So when we did that, we had a quickie video from Dr. Kosnet. And Dr. Kosnet, again, he's a toxicologist from Colorado. And the key thing he told you is that there was enough hydrazine in the real water to cause these injuries. Can we have that, Shane, please?
Well, I know something about it. I know what was present, what as described in my report, I understand that concentrate was used to produce real water that was used by consumers. And I know information on the amount of hydrazine that was measured in the concentrate. So I wouldn't say I don't know anything about it, but as the opinions expressed in my report, which I stand behind, is that the contamination of hydrazine in real water was of a magnitude capable of causing hepatotoxic illness in some consumers.
Okay, and the only reason we're presenting this, there's no real dispute about this, but I want it to be crystal clear in everyone's mind that there was enough hydrogen in this real water to cause these injuries. I don't want any doubt about that. That's what Dr. Cosman said. And if you notice, the defense didn't call a toxicologist to rebut any of this, that they're going with this. And Dr. Hudson also told you this.
Well, I know something.
Okay. Remember Dr. Hudson, he was our hepatologist. He said that there was enough hydrogen. Go ahead, Shane.
And we know from Dr. Dadhouse, sworn testimony that Severin also showed some form of fibrosis, surrounding nodules. That is correct. So of the 1, 2, 3, 4, about 5 options that we're aware of, 3 and 5 showed permanent damage. Is that correct? That is correct. Would that also indicate that more likely than not, that those who suffered acute liver injuries by consuming real water also suffered permanent liver injuries? Yes, sir.
We're getting the permanent damage in a lot of detail in a second. But I'm just showing this to highlight the fact that Dr. Hudson also said that these injuries were caused by real water. And there's really no dispute that real water had hydrogen in it. You know, we had, Shane show the concentrate test results. Okay, here's the FDA one. You've seen this a couple times. 1.44, 1.75, 1.33, 3 different test results, all showing exceedingly high levels of hydrazine. This was the testing that the FDA did after everyone went to the hospital. So no doubt about it. 3 out of 3 in the concentrate. Next, Shane. This is what I referenced real quickly earlier. They tested retail bottles. They took retail bottles, sent them back to Eurofins. You heard the testimony from the Eurofins guy yesterday. Kind of boring, but his point was that there was hydrogen in these bottles. 7 out of 7 showed objective evidence of hydrogen. Next, Shane. And I just want to show you, so we tested 7 bottles, 3 samples from the concentrate. 10 out of 10 found hydrogen. So there's no doubt that there's hydrogen in the bottle. Next, Shane. I showed you this during the opening, and I just want to emphasize, we have 5 children in this case. Real Water promoted the product to be given to children. This is some of their literature. They promoted it. They wanted children to drink it. Next, Shane. So, let's focus on the first question, compensatory damages. So here are the dates of the hospitalization again. Those on the left are the dates of how old the children were. Seven's 22, Kristen or Wren, 2 years, 8 months, 32 months. Hera is 5 years old, Lyric in London. I think the mother said they were born 1 minute apart, so they're both 7 months old. That's the date of the hospitalizations. 15 days, 6 days, 12 days, 13 days, 13 days. Total, all of them, 59 days. Okay, and we're going to go through the evidence on each one of them. Next, Shane. So you've heard all about this, AST, ALT. So these are the highest ones that any of the children had. Like I said, here in opening, Hera wins easy. She had 12,055, pretty astounding level. But all of these are unbelievably high, okay? 3,941. You see the normal range there, 15 to 27, 12 to 78. So even the 800 on the ALT is 11 times normal. The 805, 11 times normal. The 715, 10 times normal. And the AST, just off the charts for these children. So no question they were injured, and this is why they were all rushed for the emergency liver transplants. And we talked about the consent forms. Every one of the parents had to sign a consent form. sending the children up to Utah for the liver transplant because it was thought that they may need a liver transplant at that time. And liver transplants, we've talked about it a little bit. You know, this is the only option. You either get a new liver or you get better. There's no other treatment, okay? There's nothing else they can do. So this is a very serious operation. And when we get back to Severin and the testimony about the cirrhosis and what Dr. Hutton said, I mean, think in your mind, Severin is going to have this operation someday. And that's why we're talking about it a little bit. Not tomorrow, not next year, not in 2 years. But remember, you're supposed to be giving damages for the next 50 to 60 years to Severin and all the children. So you have to take this into account. Again, here's the hospital days. So let's focus on Severin a little bit. Go ahead. Okay, so first thing we talked about is encephalopathy. Remember the psychologist here who said, oh, I didn't see encephalopathy in the medical records, so they didn't have that encephalopathy. And then the very next day, Dr. Lim, the defense hepatologist, tells you, oh, they all had encephalopathy. The very next day he says that. So this is Dr. Hudson explaining what encephalopathy is.
Okay, and then finally, this goes back to the encephalopathy we were talking about, but it also talks about the swelling, the brain swell. Why is that?
Again, that's because of the increased ammonia in the blood, because it's not being cleared. It's not just ammonia, there's some other things called GABA, GABA, there's a number of transmitters in the brain. And when those substances build up, the GABA, the ammonia, and those other things that we know are there that we haven't identified, then that can cause swelling in the brain.
Liver cleans toxins. One of the toxins is ammonia. The ammonia is not clean, so it goes up to the brain. That's what causes the swelling. The swelling was so bad in Severin that they did this thing that was called lumbar puncture. They took the needle, boom, back of the head, they did spinal tap. This is the medical record documenting it. Let me have Mr. Morales' testimony. George told us about this procedure.
George, this is a note from the November 6, 2020 visit at UNC. And under procedures, it references a lumbar puncture. Do you recall that occurring at UNC?
Clear as day. Hearing your kids scream like that from a spinal tap, and just imagine like going through chemotherapy and doing all that you need to do to get yourself right, but then seeing your kid poked and prodded after that. I mean, it was, to hear him screaming, I had to hold him in my arms. I was the only one there at the time. His mom didn't come for probably like 4 or 5 hours, so back to sleep. My body's fatigued because I'm just not eating or drinking anything, and nobody in the hospital helps you with your kid. Like, you have to hold your kid when that kid's like 30 pounds, screaming and crying and doesn't know what's going on, and he's just getting these injections it was almost every hour. That just kept doing their test after test after test just to see like it was something that
Okay, let's focus on that for a minute. Just from that testimony alone, you see the past injury to Severin. You see the past anxiety of the father. And that's what encapsulated in that first part of the verdict form I showed you. The past. Okay? This is what happened in the past. So that's what you're trying to compensate for. And then he's talking about test after test. I'm going to play you a little clip. Remember, pretty much every one of these babies, they're small, so they have problems with veins. So every 2 hours, 20 times, and this goes on for days, they're trying to find that vein so they can pull the blood out, because they have to do that AST/ALT test. The nurse is going to keep going. She has to do it 40 times. But so that is a past suffering by kids. And the parents watching that happen, that's past anxiety, just to separate past from future. All right, go ahead. That's the consent form I just talked to you about. Every one of the parents signed that. They sent them up to Salt Lake. And think about this for a minute. When you're considering past anxiety, in the middle of the night, in most of these cases, you're told that your child has to take an emergency flight to Salt Lake for a liver transplant. In the middle of the night, you're told that. You know, and then your child looks like this. All right? This is a picture of Severn. I think it's right before the flight to Salt Lake. Next, Shane. Let's turn to Chris Noah Wren. Okay, here are the problems he had. Vomiting. All right, and you know, we had a lot of testimony about the vomiting. This is just not regular gurgle, throw up, vomiting. You know, almost every one of the plaintiffs told you that this was projectile vomiting. You know, I don't want to date myself, but if you remember that old movie, The Exorcist, that was a projectile vomiting from Linda Blair, okay? That's what we had in this case, and the doctor explained it in a lot of detail. Even though there's nothing left in the stomach, the body still is trying to eliminate the toxin, so you keep vomiting. And so what happens? If there's nothing left to vomit, what happens? You're vomiting blood. You're doing projectile vomiting of blood. And I think probably the best testimony on that was Mrs. Carrier, I believe, talked about it, but a couple of the others did too. So all these children, they're in this medical condition. Again, we have the high. Go ahead, next one, Shane. So this is Chris Wren's description of what was happening in the hospital. Go ahead.
They come in every 30 minutes for 6 days, taking this kid's blood, and his veins are collapsing. They're bringing in pain specialists. They're giving him off his feet. They're trying to bring toys in. He can't eat. The vomiting turned him off from food to where that became the issue in the hospital. Back to the INR, the sugars, and the issues. In order for them to let little Chris out once he was off the IV, he had to eat and his sugars had to be up. He couldn't process, his liver was broke down, so his sugars were low, and that was a
INR.
They're big concern, like my INRs.
Okay. INR we haven't talked about much, but that just means blood clotting. So if your INRs are higher than normal, normal's under 1, and all these people, I think Chris Wren Sr., he got up to 6'5", a lot of the kids got up to the 6s and 7s, so their blood couldn't clot, right? And so what the doctors were worried about, and Chris told you this during his testimony, I don't think we have this clip, but they're worried about you bleeding out. If your blood's not clotting, if for some reason you get cut, you might bleed out. And then what are they going to do? Then what are they going to do? So that's why they're watching the INRs. And like I said before, we haven't really emphasized that much, but they were all high. Next, Shane. Oh, this is Emily, and I'm just trying to focus on the anxiety. And this is a past damages. This is what a mother goes through when she's got to sign this consent form. Okay, next, Shane.
And filling out this and having to sign this form, what were you thinking at that time? The worst thing, first my husband, and then my baby, and then I'm sick, but I didn't know what it was. They were saying it was anemic. I mean, you can't explain it. And how does baby Chris through all of this? It's been a struggle every day. It's hard because he doesn't communicate. He doesn't have his device, and we're working on that. I work with him every day. We're working on new things. It's just, I'm sorry.
Okay, and let me play another clip from her. And remember, this is an autistic child. Okay, this is an autistic child, and this is what they're doing to an autistic child because, like I said, they have to get the AST/ALT readings. They got to get them. So whatever it takes to get blood out of this child, they'll do. But here, Shane.
Yes, he had IVs, but it was hard because every 30 minutes they were pricking him, so there was no rest for either of us. It was probably the scariest moment of my life. To have your child doing like that and you don't know what's wrong, and to keep coming back and forth, and you're begging the nurses, like, give him an hour, and his veins were collapsing. They had to go through his toes. They brought a specialist in. It was the darkest time of my
all these babies went to the hospital, the ICU here in Clark County, and into Salt Lake during COVID. And you heard the testimony, you heard the testimony up in Salt Lake. They were wearing I think someone referred to it as hazmat suit, but this is not a normal time to be going to a hospital. And so all of this is in the past. This is the last 3.5 years. So this goes into the past damages category, not the future damages category. All right, and then hair carrier. I'm just doing a little placeholder here because Mr. Merkovitz is going to talk to me a little bit. These are the Williams twins. So Lyric on the left, Ryan on the right. So Lyric. I mean, look at that AST reading, 5,393, approximately 100 times what it should be. And the ALT, like I said before, I'm not the greatest at math, but that's up there, all right? So Lyric goes to the hospital first, and then she has bradycardic episodes, okay? Heart problem. They bring her in, and so they had to do the emergency intubation, stick a tube down your throat to allow you to breathe because they're blurred, all right? And so this back shape, go back. So acute encephalopathy. Okay? Remember, the defense doctor said they didn't have encephalopathy, and the medical records are all saying acute encephalopathy. And obviously they had encephalopathy, even the Dr. Wren admitted it. But anyway, so we have what they call hepatic, meaning liver, hepatic encephalopathy. All right? So range swelling. And Lyric got so bad, let me show it to you in a second. Next shape. So constant monitoring. Have to have constant monitoring or she's going to die. She was in a coma. Go ahead, Jim.
I believe this is something that no parent wants to see. But at this point, the medical records are concerned about permanent organ system dysfunction or death. Is that how close it ever came to that?
Yes, sir, it is.
And was that a level of seriousness that most of the parents face?
Yes, sir.
Think about that for a minute. Every one of the parents in this case signed a form saying, you're going to Salt Lake now or your child might die. Every one of them faced that. So Lyric goes up to Salt Lake. Here we have, see the ammonia at 50? 50. And like I told you, under 1 is where we need to be. So they send her up to Salt Lake. Private jet plane in the middle of the night. Go ahead, Mission. Here she is at the hospital. All right, is this the video shoot? Okay, so this is just a 20-second cut of the 2-minute video because I think this makes the point, all right? She's in coma, non-responsive at the hospital. And this is what her mother has to look at day in and day out while she's up there. Next. And I've got to give a hand to the doctors up at Salt Lake. They did a fantastic job. Remember the MMR? One person drank real water and died. They did a fantastic job saving this baby's life. Okay? But this is what the mother had to watch. Connection.
So despite now almost over roughly 2 minutes now we're done, did you ever see her move?
I did not.
Is that an indication of how sick she was?
That tells you that she's in a coma, and that means encephalopathy. Encephalopathy, we have grades for everything in liver disease. I'm sure you guys are not seeing that now. So grade 0 is normal, and there's a grade 4 encephalopathy. Grade 4 encephalopathy is a coma. That's what she got, the worst you can have.
Worst possible encephalopathy, coma. She's in a coma. You saw the video. I told you, this is the past, okay? But let's hear some testimony from Shante about what trying to explain to you what she was going through.
Hearing that news, what was that like? Devastating, heartbreaking. I didn't understand the concept of her needing to have a transplant, her liver transplant. I just remember that they told me that she was going to need a liver transplant, that they were looking into putting her in a different facility because they don't operate on liver transplants out here. So it's just a bunch of information coming at me at once, but they just told me you need to go pack and prepare to get ready to apply to whichever facility we decide we want to take her in, but she needs a transplant right now.
Same thing, all 5 babies, same thing, all the parents told them that they needed a transplant. Next year. Picture of the baby again. Again, this is Larry. You can see, this is when she's in the heating tent because she's so cold they have to heat her up. Go ahead, Jenny.
This is Lyric, and she is she's unconscious because at this part they had to put her in this little bubble thing because she was extremely cold. Like I said, her skin was clammy, and they needed to make sure that they kept her body temperature warm. So they put her in this thing that to keep her body temperature at the level that it needed to be in. So
summing up, Lyric spent 2 days at Sunrise, then she spent another 11 more days at the Utah hospital. So she's in the hospital a total of 13 days. Next, please. This is London, the twin sister. So the very next day that Lyric goes up there, she starts vomiting. And again, you see they reference the hospital records to the projectile vomiting. This isn't just ordinary vomiting, this is projectile vomiting. Similar symptoms, another emergency transfer to Utah due to liver change. So not just one of your children, but both to go up for liver transplant. Again, these AST, ALTs, not quite as high as some of the other children, but 60 compared to 2,075. You know, again, it's 30, 40, improving on that math, but it's extremely high. Next, Shane. Same thing. They told them you got to do the flight for life, got to get up to Utah, or she might die. Then she gets up there, she gets worse. The ASTs actually go up, and remember during opening I told you that seems to be what happens here. So they go to the hospital the first time they get measured, and then as time goes by and the real water goes through the liver some more, they actually get higher, the damage is greater. Go ahead. Unexplained, they didn't know what was going on. Connections. So here's what the mother said about her anxiety, her suffering, and that both of her children were in Utah, have to have a liver transplant or they may die. One in a coma. Go ahead.
So you were forced to go between both the girls? Yes, that was the hardest part for me, is just trying to keep up with what's going on. But for them to be separated, I don't know why. I don't remember why they were separated. But London was put in a department that was completely far away from where we were, and in that room she was pretty much by herself. So just having to leave her to go run to Lyric to see if she was okay and then come back to London.
Most of the time Linda was up, she was not unconscious, so to happen to leave her and go see her twin and for her to be hysterical and crying and it was just a very tough situation for me to be in and see them in the conditions that they were. It was very hard. It was very hard to have to see them in that situation.
So 24 hours a day in a COVID-restricted hospital, you're running from one floor to another floor, and every time you leave the child that's away, she starts screaming, "Where are you going, honey? Where are you going?" Then where you go, you see the child who's in a coma, near death. This is the past pain and anxiety. This is the 3.5 years I was telling you about that you have to compensate. So summing up, again, Chris Noah Wren wasn't in there quite as long, but if you remember right, the dad told you why. They just didn't want him to be in a COVID-restricted hospital with autism, so they got him out of there probably a little quicker than he should have gotten out. But that's why he's got 6 days instead of 15. He's just as sick as everybody else. But that's the total hospitalization. Now, I told you we'd talk about the permanent scarring, okay? So 2 doctors explained scarring to me. First, this is what Dr. Dabnett said. In fibrosis means scarring. Okay? I think they've said that enough, but I'll say it one more time. When you hear the word fibrosis, that means scarring in the liver. Okay, go ahead.
Okay, you mentioned fibrosis, so fibrosis is a scar.
Fibrosis is a scar.
Is it normal for children that are 7 months, 2 years, 5 years old to have fibrosis?
It is not normal for anyone to have fibrosis.
Okay, and fibrosis, is that good or bad?
Bad.
Why?
It strangles the liver cells, but also strangles the bile ducts and it also strangles the blood vessels in the portal area.
Okay, and similarly, this is what Dr. Hudson told you about fibrosis or scarring.
And do you ever get to a point where you cannot address the scarring and you actually have to use the liver transplant?
Once you become cirrhotic, that's irreversible.
Okay, and I'm playing this clip twice because right here we introduced the concept of cirrhosis. That is the ultimate fibrosis. That is the end stage fibrosis. So when you have cirrhosis, that's irreversible. And I can show you Dr. Lim's testimony in a minute, the defense hepatologist, he admits that. Once you have cirrhosis, there's no going back. Okay? It doesn't get better. These kids aren't fine. Once you have cirrhosis, that's irreversible. Next one. Okay, so this is Severin's tissue slide, right? So remember, Severin had not just the lumbar puncture, but they did a biopsy on him. So him and Hera both had biopsies. Chris Wren, they wanted to do one, but the parents said, no, he's autistic, we're not going there. And then London and Lyric, for some reason, they didn't do biopsies on them. So here is the actual picture of the tissue that was taken from Severin Morales. And so now, and I will let the doctor explain it, but I'm just going to give you my take on it. So when you look at this, you see the circle there? You see how the blue, which is the scar, remember all the discussion about the trichome stain? You have to use the trichome stain to bring out the fibrosis picture. So the blue from that stain is fibrosis. So this is actual fibrosis that's taken from Severin's liver. And as both hepatologists admitted, this is throughout the whole liver. Okay, you don't get a bad section with cirrhosis and all the rest of it's good. It's pretty uniform when you have a problem in the whole liver. Both of the hepatologists told you this. So this is see how it's a circle? Okay, it's a circle. And so what they call from the top to the left and the top to the right, that's what's called bridging fibrosis. Okay, that means you get a scar that's going from one portal tract to another. Remember they explained that the liver has hundreds, if not thousands, of portal tracts. So if you get fibrosis between the portal tracts, that's bridging fibrosis. It's bridging between one portal tract and another. When you get it and it's going through a number of portal tracts, in this case it looks like 5, that is cirrhosis, okay? That's in a more advanced condition. So you get the bridging fibrosis first, which develops into cirrhosis. This slide is probably the best evidence of the cirrhosis in this case, because this shows unequivocally, and their doctor admitted it when he finally got shown the slide, unequivocally that Severn has cirrhosis, all right? Just look at the round circle there. And now let Dr. Dano explain it to you in doctor speak.
Okay, so as I mentioned, the complete surrounding of a nodule with fibrosis, that's cirrhosis. And the fibrous tissue scar stains blue on the trichrome stain. And once it gets to this stage, it's irreversible.
Shane, 2 more. The next one, please. Continue the same thought.
So these are my notes, and this is the slide that I reviewed. And there's a portal area there. There's a portal area here. This is the central vein. Several things I want to point out. The most important thing is the bridging fibrosis. Here's the portal area. There's this bridging fibrosis to the next portal area. There it is to the next portal area. And there to the next portal area. Now the biopsy is very limited. It's a thin piece of tissue, maybe a little thicker than a needle. And so it doesn't give you the full picture, but most likely this joins up and that would be a cirrhotic nodule, cirrhosis. But what I can say here is about 75% of the nodule is surrounded, at least on this section, and this is bridging fibrosis on a scale of 3 to 4, where 1 would be mild, 4 would be cirrhosis. This would be a 3 out of 4. But I suspect that this would be a full cirrhosis.
Okay, and so what he's saying here, ladies and gentlemen, is the bottom of the circle is cut off. You know, when I like to take pictures of people, I always cut off their legs because I don't know what I'm doing. So what happened is when they did this tissue slide, the bottom got cut off, so he can't see what's going on the bottom there. And that's why he told you he's only 90% certain this is cirrhosis. Remember, we only have to prove more likely than not, you know, the feather. So the doctor said he's 90% certain, and they didn't bring a pathologist. If they thought that this was wrong, they could have brought their own pathologist. They didn't bring a pathologist. So the only testimony we have is from him that 90% certainty that this is cirrhosis based on what we've seen here. Shane, I have one more?
Yes.
Do you see more than one cirrhotic nodule?
There's one here. There's this one here. There's this one probably here. Another one there. And this is irreversible. This would not recover.
And the one on the left, is that about 75 or 80% what?
This looks to me, you can see there's glue going around here. We're maybe missing a little bit here, but that's about 80% bridging. But this is all totally abnormal.
And no questions mine that Severn has cirrhotic nodules.
I would say with 99% certainty it's cirrhotic, but I can't say to you on this slide that I can show it to you. What I can say is that my experience of seeing hundreds, if not thousands of these cases, that this is really part of cirrhosis.
Okay, and again, he doesn't just see it in one place. We have 5 different rings here. The Olympics are next month. Olympic rings are good. These are bad rings, okay? The blue there is scarring, so you can see 5 different rings there. No question that this patient has cirrhosis. And I said he was 99% certain. I misspoke. He said 99% certain. Okay, that's what the testimony was. Now, what does this mean? What does this mean that you have cirrhotic nodules? What's that mean to your future? Okay. this is what Dr. Hudson explained to you, and again, we're trying to past and future. Now we're looking at the future for all these children, 7 especially. Go ahead.
Were you aware of the fact that Dr. Datnow testified that Severn has bridging fibrosis in the November 2020 slides that he reviewed, and that he found multiple nodules in that area? Are you aware of that?
I'm aware of that.
Are you aware of the fact that Dr. Datnow is a board certified oncologist?
Yes, sir.
And if Dr. Datnow is correct in his review of Severn's biopsy slides, does that indicate permanency of the injury to his liver?
Yes, sir, it does.
Okay. Hold right there, shoot. No, that's fine. No, just a second. So we have tissue slides from Severn, but we don't have tissue slides from 3 of the children. 2 would be the Williams twins, and the 3rd one would be Chris Wren, because again, he's autistic, they didn't want to do it. And remember, the doctors explained to you, they just don't want to stick these big needles in your liver for any, you know, they're pretty reluctant to do that. So if the hospital didn't absolutely have to do it, they didn't do it. So we don't have tissue slides for 3 of the 5 plaintiffs, we just have 2 of them, Morales and Carey. But what do we have? We have Severn, who we know has 5 cirrhotic nodules just on that one slide. 5. And look at his AST compared to the other children. I mean, Chris Wren is higher. Carrier is 3 times as high. Lyric is higher. London's slightly lower. The AST, Severn's low. He's almost the lowest one, except for Lyric and London. But look at Chris, he's higher. Hera's 2.5 times as high. So I mean, this was one of the things. We looked at the INR too, we talked about Richard. Applied his experience. This is one of the reasons that Dr. Hudson told you that it's more likely than not that all the children have protein scar. Well, they didn't refute that. I knew your Dr. Wren would refute that. I know he started out saying, oh, these kids are normal, they're going to be great. And then it turned out that the defendants, and they'll explain why, the defendants didn't provide Dr. Lim the slides to look at. They didn't provide Dr. Lim the trial testimony from Dr. Datnow. They didn't provide Dr. Lim the trial testimony from Dr. Hudson. And when Mr. Parker showed him all that, look how fast he flip-flopped, okay? All of a sudden he said, yeah, you're right, this is cirrhotic, this is permanent. And I'm going to show you that in a minute. But this is the basis, among other things, for Dr. Datnow's opinion that it's more likely than not. What did that mention?
Mr. Hudson?
And we know from Dr. Datnow's sworn testimony that Severn also showed some form of fibrosis, cirrhotic nodules in that.
That is correct.
So of the 1, 2, 3, 4, about 5 options that we're aware of, 3 and 5 showed permanent damage. Is that correct?
That is correct.
Would that also indicate that more likely than not, that those who suffered acute liver injuries by consuming real water also suffered permanent liver injuries?
Yes, sir.
Can you back just the testimony down a little bit, Shane? I want to make a point here. Okay, so what is he talking about there? 2, 3, 4, or 5 options? Remember that Mr. Parker showed Dr. Datnow the article, and that's the article that was written by someone named Dr. Bird. She's up there in Loma Linda. That's an exhibit. I can't remember what exhibit is that for. It's 6. It's one of the early exhibits. But if you take a look at that at the back, they have pictures. Same kind of slide I just showed you from Severn. They had the pictures, and in those we're seeing the bridging fibrosis. We're seeing permanent injury in these other people that drink real water. Some of them for as long as 2 weeks. 2 weeks. Okay. And Mr. Parker showed you some of the articles. I mean, 1 minute exposure, someone died, an airman unfortunately died. So this is highly toxic stuff. So this is what he's talking about here, 2, 3, 4. He's looking at the other slides, adding them up, doing some multiplication, trying to project whether or not the other children have the same condition, and he says they do. And remember, it's more likely than not. More likely than not. Okay? We don't have to prove this by putting the patient. It's more likely than not. And this definitely proves it.
Okay, council can come approve.
Yes, Your Honor. I think the judge wants to.
Thank you. Ladies and gentlemen, we're going to take our lunch break. Like I said, it's going to be shorter than normal. We have lunch provided in the jury room. Don't deliberate yet because you don't have everything in front of you, so this instruction still applies. So during this recess, you're admonished not to talk or converse amongst yourselves or with anyone else on any subject connected with this trial. Do not read, watch, or listen to any report of or commentary of the trial or any person connected with this trial by any medium of information, including without limitation to social media, text, newspapers, television, internet, radio. Do not visit the scene of any events mentioned during the trial. Do not undertake any investigation. Do not do any posted communications on any social networking sites. Do not do any independent research. Do not do any independent research, including internet searches. Do not form or express any opinion on any subject connected with the trial until it is finally submitted to you. See you back at 1:05.
Please rise for the jury.
Kemp, you ready to continue?
Yes, Your Honor. Afternoon, ladies and gentlemen. I forgot to thank the court staff before I started. And the court staff's done an unbelievable job. You know, you've had 30 witnesses in 6.5 days. That just doesn't happen, okay? And a lot of it's because of the hard work of the court staff, so I'd like to thank them. So getting back to where we were, let's go back to the last clip I played, just to try to get back in the flow. So this is Dr. Hudson again saying that it's more likely than not that all children have permanent injury. Go ahead, Shane.
And we know from Dr. Dadhouse, sworn testimony that Severin also showed some form of fibrosis, cirrhotic nodules.
That's correct.
So of the 1, 2, 3, 4, about 5 options that we're aware of, 3 to 5 showing permanent damage. Is that correct?
That is correct.
Would that also indicate that more likely than not, that those who suffered acute liver injuries by consuming real water also suffered permanent liver injuries?
Yes, sir.
Okay, so permanent injury, so we're talking about cirrhosis here. And cirrhosis, it doesn't reverse itself, it's irreversible. And sooner or later, and this is what Dr. Hudson's going to tell you, sooner or later, there's going to have to be a liver transplant. Go ahead. Oh, whoa. Would you play 107, 13 through 22, Shane? Is that what we just played?
No, 112, 12 to 21.
Yeah, so the next one's Dr. Hudson, 109, 25. Dr. Lim's after the next two Hudson cuts. Have to excuse my lovely assistant over there. Go ahead.
In your experience as a board certified hepatologist, when you've seen those types of cirrhotic nodules, has that ever indicated the need for some form of liver transplant?
At some point, that is an irreversible situation, irreversible scarring. How quickly that progresses to a liver transplant is variable, but it always progresses.
Okay, the cirrhotic nodule, that's the blue circle. And so what he's saying here, it's irreversible, but it's variable how long it will be before there's a need for liver transplant. progresses to that point. And so that, again, that's in the future damage category. Can we have the next one, please, Jim?
And just for the benefit of the jury one more time, since we've had lunch and perhaps we got some of this, Dr. Datnow's opinion would reflect a permanency of bridging fibrosis around certain areas, portals within the liver.
That is correct, as we discussed earlier on the pictures about the fibrosis.
In your experience, has a development of that level of fibrosis, in fact, I believe he called it cirrhotic nodules, could lead to liver transplant?
Yes, sir.
Okay. And then they misspelled it there, that's cirrhotic, not sardonic. Mr. Parker said it right, but that's it. Now, I told you before that we would show you the defense hepatologist, again, that's Dr. Wren. Seemed like a very impressive guy to me, pretty young, I mean, made me feel old, but, so this is what Dr. Lim said. Go ahead, Shane.
Okay, Dr. Wren, based upon what you just heard from Dr. Hansen, when we played again, I remember it. Okay, and what you heard from Dr. Datnow, the cirrhotic nodules typically progress.
Yes, by definition, cirrhotic nodules is cirrhosis, and that's severe irreversible scar tissue. Yes, sir.
Okay, so you agree with Dr. Hudson and Dr. Datnow on that?
Yes, sir.
And can that progress ultimately to a liver transplant?
Yes, sir, it can.
There's no dispute here. This is the defense hepatologist. He's telling you that cirrhosis, the cirrhotic nodules, progresses, and that's ultimately going to lead to a liver transplant. Again, we don't know when. We don't know when these children will have a liver transplant, but they will have a liver transplant. And that's on the
Objection, Your Honor, approach. Sure.
It's been sustained, which you can't go ahead and clarify.
And so it progresses to a liver transplant. We're not asking you to award anybody damages for liver transplant. Okay? But this is the testimony of the defense hepatologist. It will progress to need for liver transplant. Okay, now the hard part. The hard part is trying to value this. You have to put a number on it. That's the hard part. And let's go to jury instruction 11. The evidence that you have to consider in this case is the testimony of the witnesses. And I've taken the middle off, it wasn't quite that short. So I've taken off what's in the middle, but this is the first sentence, the last sentence. So what I argue, what Mr. Odou argues, that's not evidence of the case. It's only the testimony of witnesses. All right. We had testimony from one witness about the value of acute liver failure. One witness told you what they thought the value was. Wasn't one of the doctors. And I don't know if you picked up on it. Here, Shane, play the testimony, please.
Okay, it says, on the next sentence it says, the debilitation of liver failure, I have been to hell and back. Did I read that right?
Yeah, it was a very terrible experience.
Okay. You want to go through this again if I gave you $10 million, would you?
Yeah.
This is Blaine Jones. This is the person that made the concentrate. He had similar injuries to what we have in this case. Similar injuries. This is the part, you remember I played some of this during the opening and we played it again, we played his deposition. He talked about all the experiences he had. He went to Utah, he went to the hospital, and he's down here in the hospital. And he's in the hospital about 8 days. And they counsel him, yeah, maybe you need a liver transplant. But he never gets on an airplane. He never flew to a transplant center. So he didn't have a severe case as these children. And there's no evidence one way or the other as to whether or not he has permanent scarring. Okay? So he's talking solely about past damages. He's talking solely about his evaluation of past damages. And he says 10 million. That's what, and he's their executive vice president, okay? So Mr. Odou is gonna come up and he's gonna say, oh, this is $10 million, oh. You know, but this is evidence. This is evidence in the case. This is not argument. This is sworn testimony from the executive vice president of Real Water. So with that number in mind, that he says past damages were 10 million, let's go to the verdict. Based on that testimony alone, I could ask you to put $10 million for Christopher Noah Wren for the past 3.5 years. I could ask you for that, but I'm not. I'm going to be conservative. I'm going to cut it in half. Okay? I'm not going to go the full way Mr. Jones said. So I'm going to suggest to you that 5 million would be an appropriate number for the past damages. And remember, this is for 3.5 years. You see the red there? That's not going to be on the verdict form, but we're just trying to compensate for the past. And that's what Mr. Jones was talking about when he said 10 million. And all these children, you know, there's certain points that seem worse on one as opposed to another. You know, I could say, oh, well, Lyric's in a coma. I could say, oh, Harris got the 12,000 AST. I could say Sevron's got the cirrhotic nodule picture. You know, so we should shake it up and down a little bit. And you have the discretion to do that. You know, if you want to put 5 million, 6 million, 8, whatever you want, you have the complete discretion to do that. But I think that these children pretty much should be treated equally. So I would put 5 million in all. So that's the past. All right, now let's take a look at the future. So the future, Shane, can we have again, this is the 50 to 60 years, however long these children will live in the future. Okay, well, let's start with 7. He's got, their hepatologist conceded it. He's got cirrhosis, a permanent liver scarring. Okay, so I suggest the same amount for each one. But again, you have discretion here. You can put any figure you want. You have complete discretion here. You can put more, you can put less, you can vary it for the children. You know, it's kind of an unusual case. They're all pretty much the same age, all right? So that's what I would suggest. And again, the total of each is 10 million, and Blaine Jones said 10 million just for his past suffering. That is the evidence in front of you. Now the next issue is just a yes or no. You don't have to do an amount on this. And this is, do they need future? Again, I told you I'm going to leave this to Mr. Merkovich, so I'm going to leave it to you. I think he's going to suggest that you check yes. Go ahead, Blaine. Shane, put that in. We're going to suggest you check yes for all of them. And Mr. Merkovich is going to tell you why. Next, please. Oh no, back to the adults, true. So there's 3 adults, people that suffer acute liver failure. That would be Christopher Brian Wren, father, Emily Wren, the mother, and Mr. Tagano. Okay, I went through their injuries with you. Go ahead. Next, Shane. So Chris Wren, same thing, vomiting. Look at this INR there, the 6.5, and one's normal, and he's way up there, so they're worried about him bleeding out. Serious injury, 3416, 1176 on the ST. Next, Shane. Next, Shane. It's going up. Remember I told you this? It goes up. It goes up after you're in the hospital. Next. This is the day I think they discharged him, and he's still at 4,934. Probably shouldn't have discharged him, but we're in the day and age of COVID at this point. So I don't fault the hospital. Next. A little bit from Emily, the wife, about how Chris was feeling.
And so we heard a little bit, actually more to August of 2020. Chris testified about how he was feeling and everything, and sitting on the couch and you walking in. Can you tell me a little bit about what prompted you kind of to go to the emergency room?
He looked like death. He was just laying there. My husband's full of life. Yes, just to see him laying there like that, hell, he almost looked green. And so I'm kind of got stern with him. I'm like, you have to go. He's never stubborn. It's hard for me to tell him what to do. But yeah, he ended up taking himself at the time because I was with the children. So.
And this is what Chris told you about his trip to the hospital.
Yeah, the vomiting started, I had call out of work, and again, I was vomiting, just diarrhea, vomiting, dizzy, but it was a different sickness than I've ever felt before. So kids, maybe it's a new virus, the COVID's going around, I don't know, whatever. So puking, and the only thing I was intaking while vomiting was real water. So you would vomit, I would fill up that thermos, the exact one we're talking about, I would drink it, 20 minutes, projectile vomit, drink, vomit for 2, 3, 4 days in a row. Called out of work, I'm not getting any better. And then I went to the ER because he vomited for 3 or 4 days. Something's weird, time to go to the doctor.
Those are his injuries. Well, suggest, can I have the verdict form? Yeah. Again, Blaine Jones says this is the past suffering. He's pretty much the same as Chris Wren. He says that's worth $10 million. I'm not going to ask you for that. I'm going to ask you for 5. I'm going to suggest to you that Chris Wren on the past, and you see how we got past and future highlighted. So number 1's past, number 2 is future. I'm going to suggest you just do $2 million and $2 million on both of them. Shane, can we have that? Okay, and then Emily wasn't as sick as Chris. You heard the testimony. She wasn't as sick as Chris. So I'm just going to suggest you do $1 million and $1 million on hers. And Mr. Parker's going to talk to you about Mr. Tagano. And so that ends the discussion of the compensatory damages. Now remember I told you we had one other question, the yes, no on punitives. So let's put compensatory aside and let's move to the punitive issue. Simple question. Are they liable for punitive damages? Yes, no, okay? And so when we started the case, I showed you a slide that we thought the 4 different things they did wrong was this. Go ahead. They didn't do the general non-targeted screening test. And again, that's the GCMS. You've heard GCMS probably too much. So when they started selling this product, they didn't do any testing to see what was in it. That's point number 1. Point number 2, the poor or non-existent quality assurance. Point number 3, Jane. They knew of serious customer complaints, and we're going to get into those complaints real quick. But they knew about it, and they didn't investigate or they didn't do testing at that time. And then 4, and this is the one that I find most upsetting. They had the vice president of sales begging for a recall. Not 1 time, but 2 times. And they didn't do a recall. And that was approximately 3 or 4 weeks before the children in this case got sick. 3 or 4 weeks before the children got sick, the vice president of sales is begging for a recall. Okay, so those are the 4 points. Let's break them down. And let's start with the testing before the product, testing the product before the sales start. Shane? And I want to emphasize, okay, because this, and when we had Mrs. Olson on the stand, I think we made this point quickly, this is not a case of someone going to a lake or a spring or a mountain and just pouring water in a bottle, and saying, here you go. This is not that kind of bottling water operation. This is an operation where they used this device. This is what held the tubes up. Next, Shane. And for 8 to 10 hours, not once, but twice, they juiced this. They applied this constant electrical charge for, if it's 8 hours, it's 16 in total. If it's 10, it's 20. I don't think it really matters. But the point is, and I think 5 different witnesses told you this, that when you do this, you're going to alter the chemistry of the product. Okay? This constant electricity is altering the chemistry of a product. And especially for that long of a period of time. Next shade. So this is Dr. Najim's trial testimony. And he told you that the hydrazine was formed right in the titanium tube process, okay, by these chemical reactions I just talked about. So these people knew that they were going to use what I would characterize as a bizarre manufacturing process, you know, applying this electricity for 16, 20 hours. They knew they were doing it. They knew that there was some kind of chemical reaction, and despite all that, they didn't do any testing at the get-go. And again, this is Dr. Najim, and he's the hydrazine expert. Remember, he wrote the 2 leading papers in the world on hydrazine. So he said that in other investigations where they've had hydrazine pop up, 1,000 to 10,000 times lower. This was a lot of hydrazine in this product. Okay? Surprisingly high concentrations is how he phrased it. And they didn't do any testing, any non-targeted screening testing. You know, they did this bacteria stuff and this metal stuff, but they didn't do the testing that was necessary to find what was in the product. And I have Mr. Marlowe in here just because I didn't want there any doubt. Anyway, this I call it the juice mix, and then they use this meter to measure. But it's pretty much juice 10 hours, then they mix it up. Next shade. Here's Marlowe. I just don't want there to be any doubt that they were using the electrical thing for 8 to 10 hours. Next. Go ahead.
And when you put the water through the tubes, you hooked up that charge was on the that was done for somewhere between 8 and 10 hours each time?
Probably, yes.
Okay. Great. So it was a constant charge of whatever you do? Yes. So for 8 or 10 hours each time, the water was getting electrified and used?
Yes.
No question that that's what they were doing. They knew they were doing it. Next, here's a picture of the electricity generator. I'm not really good on equipment, but this is what they were using. And Mr. Marlowe, remember his testimony? They played with the amps and voltage until he found the thing that didn't make him too sick. So that was what became the product. And they knew about these GCMS machines. He'd heard about it. Go ahead, Shane.
And have you ever heard of a testing machine called a GCMS, gas chromatograph mass spectrometry?
Yeah, I've heard of it.
Okay. Did you do any testing on that?
I'm not familiar with that, so I don't know if the lab did or not.
So you've heard of it, but you didn't do anything?
No, I didn't.
And do you know of any testing that was done, screening testing, non-targeted testing, any testing by anyone other than when we talked about the bacteria and the metals?
Not that I recall, no.
No GCMS testing to do non-targeted screening. And we asked Blaine Jones this question too. Go ahead, Jim.
One more from Marlowe first.
Oh, we have one more from Marlowe. Go ahead.
Did you do it any time, any non-targeted testing to find something like hydrogen?
No.
No non-targeted testing, which means that unless they knew what to look for, like the bacteria or metals, they didn't test for it. They didn't do the screening test. I think Mrs. Olson, the defense bottled water expert, she called it a library search. You're trying to look at, what's in your product, 300 or 400 different substances. They didn't do that at all. Okay. And Mr. Jones admitted it for 14 years, 2008 to 2020, he never tested for hydrazine. Is that just it?
No
Oh,
video.
okay. So, this is his testimony, we're not gonna play it for you. And we cut off at 2020 because remember the FDA found it in 2021. So for this 14-year period, they didn't test for hydrazine. Now, Mr. Odou's gonna get up and say, oh, we didn't know there was hydrazine in here. Okay, so we didn't have an obligation to test for it. That's what he's gonna tell you. Well, you should know exactly what's in your product. That's why you do a non-targeted screening test. You try to cover the entire spectrum, including hydrazine, including these other 499 things. That's why you do the non-targeted screening test. You know, his suggestion that, oh, we should only test for what we know, what kind of safety measure is that? And this is what Dr. Hutt explained to you. Remember Dr. Hutt? She was the quality assurance expert that worked for McDonald's and Yummy Brands and Coors, and I can't remember, and she was with the FDA, and, you know, pretty experienced person, I think you'll agree. And this is what she says, that when you bring out a new product, a new water product, they should have used the machine, GCMS machine, to do these tests. Go ahead.
And do you have a view as to whether or not, when you bring out a new product, like this new water product, they should use this machine to do tests?
Well, two things, yes. As I mentioned, it is a regulatory requirement that there be an annual test for contaminants, environmental contaminants, but then also in just screening a product that has a very complicated chemistry process involved in its manufacture, which is real water. I mean, you're adding and deleting electrons from water to change the pH of natural water. It's a chemical process, a very complicated one. It's elemental chemistry, so you have lots of things that can go wrong. And it is an opportunity to really find them before they become problems by using such screening technology as GCMS.
Okay, and Dr. Hutt spent some time talking to you about the GCMS machine, and we talked to Ms. Olson about it on Monday. And $100? It would have cost $100 to do this non-targeted screening? $100, and they didn't do it? And I asked Ms. Olson, is it the money? Oh, no, we just can't do it unless we think there's something wrong. Well, that is just so wrong on so many levels. But in any event, there's no dispute in this case that if they'd done a GCMS test, they would have found the hydrazine. And how do we know that? Because that's what the FDA did. They did the GCMS test, the non-target screening, and they found the hydrazine. All right, so let's take a look at the key testing facts here. So, you look for 500 toxins, including hydrazine. I say 200 to 100 in the 1,000 in the slide, but the testimony from the stand was it costs 100. They didn't do it. No dispute that they didn't do it when they started or during the entire time up to 2020. You heard Mr. Jones's testimony. For 14 years, they didn't do any kind of non-target screening. And the inventor, you heard Mr. Marlowe, he said they should have done it. FDA did it, and they found the hydrazine. So that's pretty much our first point. What is their defense? What do they say in response to this point? Okay, go ahead, Chief.
And did you know any testing that was done, screening testing, non-targeted testing, any testing by anyone other than when we talked about the bacteria and the meds?
Not that I recall, no.
So they throw a little curveball that we try to illustrate here. They've got all these bacteria tests by Wet Lab or Western or whatever it is, and they have these metals tests that are done by them, and they say, oh, look, we tested for bacteria metals. We didn't know about hydrazine. Those are not non-targeted screening tests, okay? That's what we're talking about here. Test for the unknown. Don't just test for the known. So that I'm calling it the misdirection. Go ahead. So they made the new product. They didn't know what was in it. Think about that for a minute. They're selling a bottled water product without knowing what is in it. Next. This is what Dr. Hutt told you next. Told you about these bacteria tests. Those are not non-targeted tests. Hydrazine-only tests are not genuine. When you look for hydrazine-only, that's why they played Dr. Neslin, Mr. Neslin's. They're trying to say, oh, this is a fancy-dancy test. He was doing a concentration test, trying to find the concentration of hydrazine. That's what Dr. Neslin at Eurofins was doing. He wasn't talking about the GCMS, which is what the FDA did. So what they should have done is just this general test, non-targeted, to determine what was in the product. So was something wrong done in this case? Something wrong done? Well, here's what the inventor told you.
Which page line, Mr. Kemp?
It is Marlowe, 66, 14 through 24. Sorry, ladies and gentlemen, Shane and I usually are a little tighter, but, you know. Okay. Go ahead, Jim.
And we talked about the FDA finding hydrogen in the water.
Yes.
That's something real water should have known about one way or the other before they sold the product. You agree?
Well, knowing what we know now, yes.
So I'm not saying you made a mistake, but someone made a mistake somewhere down the line.
Something went wrong, obviously, yes.
The inventor. Something went wrong, obviously. They should have done testing. He said that. So that's the first point that we think justifies checking the box yes. And remember, you don't have to find yes on all four of them. It's just if you think that the real water has engaged in punitive conduct. And I think Mr. Parker is going to amplify on that a little bit. But here's the second point, all right, the quality assurance. Again, let's talk about what is quality assurance. This is Dr. Hutt again.
So I look at Real Water's program, and they didn't have quality assurance. We talked about the concentrate. There was no standard operating procedure for manufacturing concentrate. It's called proprietary. That's fine. They're proprietary things. KFC's 11 herbs and chicken recipe had a proprietary recipe as well. Ketchup had, Heinz ketchup has a proprietary recipe, but it's documented and it's not accessible to everybody, but those who need to know it, and those who are in manufacturing of that product are aware of how they do it and how they do it consistently. So we're not trying to keep information hidden. You're trying to document information and convey it to those who need to know it consistently so that product can be made the same way every time. So the issue with Real Water is they didn't have standard operating procedures, not for concentrate, not for anything in their operation. They had a variety of other, I call them faux pas, deficiencies in their quality program. They didn't have labeling, for example. The chemicals were not labeled. That's a recipe for disaster because you don't know what's in a container if it's not labeled. You could be putting sanitizer in something that's an ingredient and you just don't know. So you want all this material to be labeled, you want it all to be documented. And Real Water just didn't have any of those basics, those fundamentals of a quality program. And then, we talk about training, they didn't have, and I know training is another element, but it's a huge piece of this whole.
No quality assurance. And she finished with training. Let's start with training, okay? Because the quality assurance director is the most important person in the quality assurance program. Obviously, everybody agrees with that. And what did they do in this case? They took the receptionist that had been there 5 or 6 weeks, and they made her quality assurance director. She admitted to you she didn't have experience. Shane?
In your view, did she have the qualifications to be a quality assurance director?
No. My understanding is that she was hired first as a receptionist, and then she was promoted to a quality or assistant quality assurance director. The issue, that's not a problem if she's trained and she's prepared for that role and knows what that role is. In this case, Ms. Converse was not trained and not prepared. She was just given a title. And that's not leadership, that's not quality assurance.
And then we had the confession. We had the confession from from Patty Converse that she was not qualified. Go ahead, James.
Now, when you got hired, you said you were hired to be the specialist, and then a month later, you became the director of quality control. I assume you've never been the director of quality control before.
No.
Okay, at least they told this person that she was supposedly the director of quality, that she was the director of quality control. She understood clearly that she was the director of quality control. She wasn't experienced, didn't know what she was doing, never saw the complaints, which we'll get to in a second. But at least they told her that she was quality assurance or quality control director. The next so-called, remember she left in July of 2017. Remember from her deposition testimony? July of 2017. And the next person that they put in that role is Mr. Desitel. He's the Army drill sergeant that we had. So they called him the director of quality assurance, but he really wasn't. Here's his testimony.
Okay. Did they call you director of quality assurance?
Yes, they did call me that.
Okay. Were you really director of quality assurance?
No, I was not.
What were you?
I was a supervisor.
And you never been involved in quality control before working for Real Water?
No, I had not.
And no training in regards to quality control?
No, I had not.
They were just putting a name on a chart where the quality control director's name needed to be without having a real quality control director. So not only did they not have someone in the position, but they were trying to be a little tricky about it, okay? And speaking of tricky, okay, remember Mr. Odou, every time we get to that December 6, 2018 audit, he says to you, oh, there was no qualified individual because that morning or the day before, the quality control director, she sent in her resignation. Okay, remember he said that to you a couple times? And I bet you he's going to say it to you again. Okay, consider this. December 6th, even the day before, December 5th, Patty Converse left in July. She left before that. She didn't submit her resignation that morning or the day before. Okay, I don't know where they're coming up with this, but that's the excuse they have for this particular finding. All right, this is the finding when the NSF auditor went in there. There was no qualified individual to provide a level of competency necessary for production of clean and safe product. Remember, they're just trying to tell you, oh, this is just something that happened because someone resigned that morning. Yeah, Patty Converse did resign, but it wasn't that morning. She told you she left in July of 2017, okay? So then we have Mr. Desitel in there during this 2018 period for whatever time period. And again, he's the one that they didn't even tell was the quality assurance director. And then we asked him, we asked Mr. Desitel, well, you know, we've seen testimony from Mr. Jones that they complied with HACCP and they knew what HACCP was and he had HACCP training and we were all big HACCP people, okay? So we asked Mr. Desitel, who, if nothing else, he's a straight shooter, okay? Here's what he said.
And did Real Water have a HACCP program?
No, they did not.
Did they have operating procedures?
No, sir.
No HACCP program. And that's why they only got a 6.7 on that December 6th, 2018 audit under HACCP. They got a 6.7. I can't remember if it was out of 150 or 250, but they got 6.7 points, all right? A miserable fail, okay? So that's the second reason we think that punitive damages are warranted. Moving to the third reason, the investigation or lack thereof, I guess I should say, regarding customer complaints. So let's start out with Dr. Hutt. She's explaining to you why a food and beverage manufacturer should investigate complaints. you know, from customers that there's gasoline-like smells or chemical smells or people were in the hospital for a week. This is her explanation.
Now, with regards to customer complaints, first of all, what should a company of food or bottom line manufacturer do with regards to customer complaints?
Well, first of all, you should collect them because they are a very important part of the feedback mechanism. You know, you design something, you manufacture it, you sell it, and then you have something to come back from the customer to say, you're doing your job. You're doing everything that you think you're doing it correctly. If you get complaints, then something is wrong. And as a quality professional, we look for certain triggers in customer complaints. We're looking for things that kind of are red flags.
Okay, so the first problem here was that the quality assurance director wasn't seeing the customer complaints. So the person that's in charge of quality assurance in the whole plant is not getting the customer complaints. And we know that for a fact. Here's Mrs. Commerce, or I think it's Mrs. Commerce's testimony.
First of all, I assume all the customer alert forms were filed in one big place, right?
I would think so. I never saw them.
Okay. You're the director of quality assurance.
Right.
So instead of having the typical quality assurance program that Dr. Hutt told you should be implemented, which is get the complaint, investigate it, see if you have a problem. I mean, pretty standard stuff, right? So instead of doing that, their program was anytime someone complained, give them some free water. Just give them free water. And here it is.
Okay, so when you received written complaints about your water causing someone an illness such as diarrhea, the solution was to send them free water.
Correct.
Okay, the solution was not to investigate as to whether there's a potential problem with the water.
Correct.
Okay? And in retrospect, do you think that was a good quality control procedure?
No, sir.
Pretty obvious. And we had some serious customer complaints here. We brought probably the most serious one to the witness stand, and that would be Mr. Watkins. And so Mr. Watkins told you that in 2018, 2.5 years before any of these babies got sick, in 2018, that's 1.5 years, I told you I'm not good at that. But anyway, in 2018, he was in the hospital for a week or two, and his doctor said it was the water, okay? That's what he told you, and he said, or actually his wife did, sent an email to Real Water telling him this. No investigation. They didn't contact him, nothing. Here's his testimony.
Did there come a time you noticed that you weren't feeling well?
Yes, I won't forget that. That was my 35th wedding anniversary. It was May 25th, 2018.
Did someone in your family share this experience with Real Water?
Through an email.
Okay, if you're not going to do the GCMS testing at the get-go when you start selling the product, you should at least do it when you find out people are going to the hospital, all right? This is a copy of the email that's in evidence. So I showed this email to Mr. Bush. Remember we played his testimony yesterday? He was the guy that used to work at Nestle, I think I'm saying that right, Nestle. And I said, well, if you, and he was the production manager, if you had known about this email, what would you have done? Go ahead.
My husband had been in the hospital for 2 weeks, and the doctor wants him to stop drinking alkaline water, unquote. Did I read that right? That's right. Okay. Did you become aware at any time that a Real Water customer was in the hospital?
No. I didn't know about that. I mean, that's not a big deal. Say, for example, I'm just we're in Nestle and something happens like this, all management would shut the plant down. It's about 15 minutes or so and just safety review it.
Right.
After actually report the military team. But no, I don't remember that.
If Nestle got a report that one of their customers drank their water and was in the hospital for 2 weeks, they would shut the assembly line down, correct?
Right.
He's not the only one that told you that. Remember I asked the same question to Mr. Desitel? Again, Mr. Desitel's the Army sergeant. was also involved in production. He was the so-called quality assurance director, you know, they didn't tell him. So we showed him some of the complaints on the witness stand. I think only 4 or 5, just a handful. And this is what he tells you he would have done if he'd known about the complaints.
So if you had known about these complaints, what are things that you done?
Stop trying immediately
And why is that?
to prevent any further contamination or whatever's wrong with it from continuing to be produced.
And what was the response from management when people told them that, hey, we got to shut this plant down and do some investigation? What was their response? This is what Mr. Destin said.
Did management have a discussion with you about whether or not you should shut down production?
Yes, they did.
What did they tell you?
Well, during the meeting, they basically admonished me for trying to enforce the GMPs and cleanliness of the line to make sure that, the filling stations are cleaned properly and the down line to make sure everything's spotless.
And you say they admonished you, what?
They basically talked down to me and said, no, you will keep the line running.
And who is this?
Wayne and Amy.
Jones,
yes.
You will keep the line running. Okay? Mr. Bush, Mr. Destel both told you that that line should have been shut down immediately and an investigation done. And I've talked about, and you're going to have all these complaints. I think we introduced about 15 of them. There were more, but we just put in 15. So look at these complaints. Here's the 2014 complaint. There was a strong chemical smell in the bottle. And then the customer said she found a gasoline-like substance in a blue, does that say blue? I think this is blue. A blue liter bottle purchase. Gasoline-like substance in a case involving rocket fuel in bottled water. Gee, I wonder what that was an indication of. Okay. Next one. Strong chemical smell is the first one. The next one is the gasoline-like substance. They had these 2 complaints in 2014. And what did they do? They did a sniff test. They sent someone out there, smells great to me, went on business as usual. That would have been a good time to do the GCMS test. So I've made a little complaint tree here so we can go faster. So like I said, you have 15 customer complaints. That's Mrs. Dorn. We showed you her video. Kessler, we showed you her video. Watkins came to trial and testified. And all these others, nausea, vomiting, confusion. Just like the plaintiffs all testified about. Fishy smell and taste. Just like Dr. Najim told you hydrazine would, if there's enough of it. So there should have been some sort of investigation. There was none. So let's see Dr. Hutt's testimony about what a serious investigation would have entailed.
And if a bottled water manufacturer got 2 complaints from the same lot, such as you indicated, what, if anything, should they have done in terms of investigation?
Well, they should have, let me back up half a step again. We have product retanks, we call them retanks. Every lot should have a product sample that is held back from sale, and you just keep it for the shelf life of that product in case something comes back. And then you can go back to that product retain and test it in whatever manner would be appropriate. In this case, they should have tested it for something along the lines of a gasoline type smell. That would have been indication for the GC, a gas chromatograph, mass spectroscopy test, something that would look for volatiles and look for whatever that unknown is. And none of that was done.
You're told that your product has a strong chemical smell, there's gasoline-like substance in it, all these other complaints, and you're not going to spring $100 to do the GCMS test. That was the decision that was made. That was the decision that was made. And we think, let me finish. So I was going to show you Kessler, Dorn, Fisherman. Remember, Kessler was the woman who lived out here in Vegas, and her elderly grandparents came out, and she wanted to share the special water with them, and so she gave it to them, and, you know, the grandparents got violently ill, she got violently ill, the cat got violently ill, so she contacted Real Water over and over again, and she told you at the end that she didn't want anything for herself, she just wanted to do the right thing, okay? So we had a person like that, and this was in late 2017, 2018, and then we had Dorn. She was the one in California who was drinking the retail bottles and had the problems, and her liver enzymes went up, and then she quit drinking it, and they went down. She sent them a complaint too, no investigation. And then we had Fisher. He was the airline person down in Tampa Bay, Florida. So he goes and he buys it. I don't remember if it was Sprouts or Whole Foods, but he buys it. He gets violently ill. He complains. Okay, you know, sooner or later, there's enough complaints that you got to get to the bottom of this, but they never did. They never did. And this is what Dr. Hutt says should have been done.
Excluding all the other complaints, the ones we talked about, the chemical, Kessler, Dorn, Fisher, excluding all those other complaints, if they just got this, what do you think they should be?
Well, it should be a trigger for an investigation. In isolation, complete, total isolation, they should have been sensitive to other complaints of individuals with them who have been hospitalized or have similar symptoms that have been described here. Again, in total isolation, that's not the case because this was not in isolation, and similar symptoms and descriptions had been made of people getting sick.
Okay, and so that's the end of the customer complaint section. And again, putting it back in context. It can be yes or no on the punitive section. And we're suggesting 4 reasons you should check yes. The first one's no testing at the get-go. The second one's no quality assurance. The third one is this customer complaint. And the fourth one is the recall situation that I'm going to get to in a minute. But we don't have to prove all 4. If you think there's punitive conduct for any one of them, or maybe all of them. So let's move to the recall situation. And they knew they had a serious problem. They knew people were getting sick. Blaine Jones was sick. He was in the hospital himself with acute liver failure. Okay? He was sick. He was told he had to get a liver transplant. And then on top of that, they had this flood of customer complaints. In Shane, can I have my next slide? There were, again, these are the questions and answers that the FDA sent written questions to Real Water, and Real Water gave these written answers. And so during this time period, there are so many customer complaints, 25 to 30 calls, that they assigned one employee, Anthony Brown, to troubleshoot them all. So they're trying to massage the customers a little bit, keep business. I'm not doing a recall. And then we get to probably the most important testimony you heard on the punitive end of it. Mr. Randolph, formerly the vice president of sales. Then in November 2015, he went to be a 1099 employee, but he was still handling all the bank accounts for him at Costco. So he becomes aware that there's a flood of customer complaints, as we see in the clip. Some of them are his relatives. And he goes in and he talks to Blaine Jones. Blaine, again, the vice president of Real Water, talking to Blaine Jones. And he says to Blaine, we've got to do a recall. We've got to do a recall. Here's his testimony.
So then, do you at some time form an opinion that the only similarity between these people would be Real Water?
Yeah, when I had a conversation with the owner's son, because I know he was, became very ill, and it probably was in October, and I thought it was COVID, and they just didn't want anybody to know. But when my nephew and another friend got sick, and then the phone calls that these guys were receiving in the office, then I asked the owner's son, his name was Blaine, I just said, I need to talk to you on a personal level. I know you were sick, can you tell me what happened? And he started describing everything that was going on, and it was identical to what my nephew and my brother-in-law, best friend, was experiencing. And so at that point, I told Blaine, I said, it's the water. I said, the only thing you guys have in common is you drink the water. Because even though my brother-in-law's best friend, comes around the family all the time, but he and my nephew don't really, they don't jive like that. They're a different age group, everything else. So at that point, I told Blaine, I said, you got to do a recall, man. There's something in the water. And that was probably beginning of November, something like that, middle of November, whatever it was.
Okay, later on, it could have been late October, like I said, that October 15th phase, that's hard and fast. That's the date that they told the FDA they had all these complaints. So that's hard and fast, we know that. This conversation, late October, beginning of November, something like that. And that was the first time he went in to blame Jones and said, we gotta have a recall. So think about this for a minute. They're getting all these complaints, 25 to 30, that's the FDA answer. Blaine Jones himself is sick. He knows two people, his nephew and his brother-in-law's friend, and they don't do a recall? I mean, they don't do any kind of investigation either. They don't start doing some GCMS testing to see what's going on, which at least would have been something, but they don't do a recall? And to his credit, Mr. Randolph was not satisfied with that. He went back again. He went back to the executive office one more time and made his pitch. We have to do this for the community. We need a recall. Here's his testimony.
He said, no, I first thought it was the water, but then I trying to remember everything that he said, trying to justify that it wasn't the water. And then I just told him, I said, Blaine, listen, we're getting numerous phone calls, according to, I think the gentleman's name was Anthony as well. They're filled with so many phone calls of people complaining. I know people that got sick. You were sick. You guys don't know each other. So it has to be the water.
He's a little amateur epidemiologist, just like Dr. Guthrie was. They're figuring this out, all right? But you don't have to wait until the FDA investigation's complete to do the right thing. This is why you do a recall. If you think there's a potential problem with the product, you recall it so you don't hurt further people. And this testimony was still about the first conversation. Shane, can I have the one on the second conversation?
So you, not only after having the first conversation requesting a recall, you had follow-up conversations with him, you're using your words, numerous conversations, all the way to the beginning of the year, he still didn't do a recall.
Yeah, because we did talk about what reminded me, he didn't want me to go out and concentrate himself. So we had conversations about, obviously, the problems that were going on, as well as how could we do something going forward.
So let's think about this. You're having your nephew get sick, the best friend of your brother-in-law, people that you're hearing about through the operations at Henderson, and despite all of that, including him getting sick, Mr. Jones getting sick, he's still trying to push to concentrate.
Yes.
This is really incredible testimony. So not only did management, Mr. Jones, say no recall, he immediately says, hey, forget all these 6 people, we got to sell some concentrate. So Mr. Randolph, I want you to go out and help me sell some more product. That's what he says in response to this conversation. And so there was no recall in October, no recall in November, no recall in December, no recall in January, no recall in February. 5 months go by. 5 months go by, they leave this product on the market, even though the owner's son got acute liver failure, was in the hospital. 5 months they leave the product on the market, even though they had so many complaints. They tasked this one person, Mr. Brown, to respond. 25 to 30 calls. So no recall whatsoever. Finally, there's a recall. So what happens between October 15th and March? What happens? Shane? Oh, excuse me, we have Dr. Hutt's testimony. Go ahead, Jay.
Okay, and you heard Mr. Randolph's testimony about Lane Jones,
Yes.
first operations, being hospitalized on October 5th. You remember that?
Yes.
Okay. How does that fit in this picture of your view?
Well, again, more evidence that Real Water knew that people were getting sick from consuming their water, and nothing was being done. Again, this should have launched a full-scale investigation and a recall. This product should not have been on the market, available for customers to buy, with this number of complaints of unknown origin for the same type of etiology, the same type of symptoms, same type of complaints. Again, something was off. It was clear that it was making people sick. Mr. Randolph indicated that he had family and friends that were becoming sick. Mr. Jones himself became sick. Again, these are just, it's all pointing to the same problem. It's the water, it's making people sick, and they did not do anything about it.
Okay. Do you think that Real Water acted properly in not doing testing in October, what we were going to call in October 2020 testing?
No, they did not act properly. They should have done testing, which would have led to a recall.
Okay, when the judge read you the jury instructions, you heard a phrase, you're going to get the instructions, you can go back to read them when you deliberate. But in those jury instructions, there's a phrase with regards to punitive damages. And that phrase is conscious disregard. Did they know about the problem and disregard it? We would submit to you, they knew. They knew they should have done a recall, and they didn't do it. Instead, they tried to sell more concentrate. Here's the jury instruction. Conscious disregard means knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to avoid those consequences. Now, how can they possibly argue they didn't have knowledge of the probable harmful consequences that people would get sick drinking their water? How can they argue that when Blaine Jones himself got acute liver failure, when they got 25 to 30 calls, when Mr. Randolph's in there begging? So how can they say they didn't know anything was going on? And they made a willful and deliberate decision to not do a recall. So if the first 3 points don't, in your view, merit punitive damages, surely this one does. And let me put the icing on the cake, okay? The icing on the cake. This is the testimony from their bottled water expert, Ms. Olson.
So if you had been consulting them on October 15th, you would have recommended that they consider a recall, correct?
That's typically how it would go. You talk to the applicable authorities to coordinate that effort.
Okay, and that's what you would have recommended?
Yes.
Thank you.
So both the plaintiffs and the defendants, experts, agreed that there should have been a recall on October 15th. They didn't do it. That's conscious disregard. And what are the harmful consequences of that conscious disregard in this case? October 15th. Let's take a look at some of these hospitalization dates. 1 month later, Sevron goes to Summerlin. 1 month later, Chris Nolan goes to Mount Ridge. 35 days later, Hera goes to Summerlin. 6 weeks later, Lyric goes to Sunrise for the first time. 6.5, 7 weeks later, after the October 15th date that their experts said they should have done a recall, London goes to Sunrise. This didn't have to happen. This did not have to happen. And that's why we think that you should check yes with regards to punitive damages. And I'd like to thank you again, ladies and gentlemen, for your attention. It's a privilege to be here on behalf of these families. And I will turn the floor over, I think, to Mr. Merkovich.